The T6 application. A tenant can use the T6 application to apply to have the Landlord and Tenant Board determine whether the landlord has not repaired or failed to maintain the rental unit or the residential complex, or has not complied with health, safety, housing, or maintenance standards. If the problem has been fixed, then the tenant must apply within 1 year of the date the problem was fixed. A tenant can make this application if they are either a current or former tenant. A landlord is responsible for maintaining a residential complex and the rental units in a good state of repair and fit for habitation. The tenant must fully explain the reasons they believe the landlord failed in their responsibilities. First, the tenant must describe the maintenance problem in detail. Details include the date the problem started and whether it is ongoing. If the problem was fixed within the last year, indicate the date it was fixed and who fixed it. If the tenant is not sure of the exact dates, they can provide approximate dates. Also, they must explain who and what may have caused the problem if known. In the space provided, the tenant should fill in the date they first informed the landlord about the maintenance problem. If the landlord is found to be at fault, there are 9 different remedies which the LTB can grant in an order for a tenant application about maintenance. If the LTB issues an order in the tenant's favor, it may decide to order a different remedy or remedies than requested. The most the LTB in Ontario can order based on claims is $35,000 as of today. If the tenant believes the landlord owes more than $35,000 and they want to collect the full amount, they should apply to court and not to the LTB. Once the LTB issues an order, the tenant can no longer have any claim to amounts greater than $35,000. Remedy 1. The landlord must pay the tenant a rent abatement. A rent abatement can relieve the tenant from their obligation to pay all or some portion of their rent for a specified period of time. If the tenant chooses this remedy, they must fill in the dollar amount of the abatement they want the LTB to order. They must also fill in the amount of their current rent and how often they pay it, for example, by the month or the week. Remedy 2. The landlord must pay the tenant for the cost to repair or replace their property that was damaged, destroyed, or disposed of because the landlord did not repair or maintain the rental unit or the residential complex. If the LTB determines that the tenant's property was damaged, destroyed, or disposed of as a result of the landlord's failure to repair or maintain the rental unit or residential complex, the LTB can order the landlord to pay the tenant compensation for the costs that they have incurred or will incur to repair or replace their property. Remedy 3. Expenses incurred. The tenant had or will have out-of-pocket expenses because the landlord did not repair or maintain the rental unit or the residential complex. The landlord must pay the tenant for these expenses. If the LTB determines that the landlord did not repair or maintain the rental unit or the residential complex as claimed on the application, and as a result of these actions the tenant experienced or will experience additional costs, the LTB may order the landlord to pay the tenant for any reasonable out-of-pocket expenses. Remedy 4. The tenant did repairs, replacements, or other work because the landlord did not repair or maintain the rental unit or the residential complex. The tenant can choose this option if they did the repair or other work themselves or purchased a replacement at their own expense because the landlord did not repair or maintain the rental unit or the residential complex, and the tenants want the landlord to pay for these costs. For example, if the tenant paid to have the refrigerator repaired, the LTB could approve the repair and order the landlord to refund the tenant the cost by a specific date. The LTB could also allow the tenant to deduct the amount owing from future rent payments. Remedy 5. The tenant wants the LTB to allow the tenant to do the repairs, replacement, or other work that is necessary, and to order the landlord to pay the tenant for their costs. The LTB can authorize the tenant to do the repair or other work, or to purchase a replacement item and order the landlord to pay the tenant for them. Remedy 6. The tenants want the LTB to order the landlord to do the repairs, replacement, or other work that is necessary. The LTB can order the landlord to complete the repair, replacement, or other work by a specific date. It is an offense for the landlord to contravene such an order. Remedy 7. The tenants want the LTB to order that the landlord cannot increase the rent for this rental unit until the landlord completes the work necessary to fix any serious maintenance problems that the landlord has been ordered to do or will be ordered to do. If the tenants want the LTB to stop the landlord from increasing the rent until the landlord has completed the repairs, replacements, or other work necessary to fix any serious maintenance problems, they need to indicate such on the form. Remedy 8. The tenants want the LTB to end their tenancy. If a tenant wants the LTB to end the tenancy due to maintenance or safety violations, this is the form they would use. Remedy 9. The tenants want the LTB to order other remedies. The LTB can make any other order that it considers appropriate, including an administrative fine. Once a landlord receives a T6 application, they should review the application in its entirety and review their records to determine if the application has any merit. It may also be worthwhile to give proper notice to inspect the unit or areas of concern to determine if maintenance is needed and arrange accordingly. Photo evidence could be helpful to the landlord's case. If maintenance is needed, the landlord should arrange for any necessary maintenance as soon as possible. A T6 application may be heard quicker than many of the types of applications, so time is of the essence. The landlord might also consider searching through the records to determine if the tenant had previously requested this maintenance, or if the application filed is the first time the landlord became aware of the issues. Ignorance is not a good defense, so consider what records the landlord has with respect to annual maintenance inspections, the last maintenance done, as requested, in the unit, or any other inspections or reports the landlord has. The landlord may find it easier to mitigate challenges before a hearing rather than waiting for an adjudicator to determine the outcome. If the T6 application has merit or the landlord is in doubt, legal advice should be sought for the specifics in the case. Like and subscribe for more helpful content.